What's good, everyone? First, I want to say I hope everyone had a good Christmas, and you enjoyed time with your family. I know it's been a while since I posted a video, so I wanted to get you guys caught up with some things you might not know what's going on. So please bear with me. I am a little under the weather. As you can tell, I have a cold. Nothing serious, but it's still dragging me down a little bit. So what's happened was there's a bill in New Jersey that surprisingly a lot of people don't know about. It was A 4796. We call it the New Jersey Kill Carry Bill. Basically, it was the response to the Bruin decision that said, the Supreme Court said you can no longer use a justifiable need to deny carry permits. So New Jersey went ahead and started issuing carry permits. And the only places that were off limits were basically schools and places that were already federally banned. So in December, it already passed the Assembly and went to the Senate. They had some amendments back and forth. Well, it was passed and passed by the Senate, I believe, on December 17th. And it was signed into law on the 22nd. Now, we knew that we were going to fight back immediately. So on the 22nd, as he was signing the bill into law, two different lawsuits were filed. Firearms Policy Coalition with other groups in that case, as well as the ANJRPC case. They kind of go after some of the same things, but one's more broad and one's more direct in what they're fighting. But let me just tell you guys about the bill in a non-lawyer speak, okay? First off, increases all the fees, from your FID card fee to your purchase permit fee to even a carry permit fee, which basically is a tax on your Second Amendment. But despite that, it also creates more sensitive places, gun-free zones that were never in New Jersey's history considered a sensitive place. We can all get behind the school stuff if you want to say that. And, my high school used to have an armed guard, a police officer, but nevertheless, they had a firearm. But for the average person, we all can think, and there's arguments on both sides to say guns don't belong in schools, right? So forget about that. But it creates 25 categories, not necessarily places, categories. And in those categories are a wide range of stuff. So, but first off, the bill would create any public gathering that you need a permit for, you can't carry there. So if it's a First Amendment march or some kind of protest that you needed a permit for, you can't carry there. It's just weird to me. You can protest your First Amendment right, but you can't exercise your Second Amendment right while doing so. But that's so broad because how would an average person walking down the street know if that particular gathering had a permit? You wouldn't know. And just a mere accidental walking into that space, even to ask if they had a permit, would be a felony. Oh. Moving on, your own car. Okay, so you can no longer carry in your own car, on your person. you would have to basically go back to one of the exemptions that allowed you to transport your firearm, meaning unload it, locked in a trunk or a compartment. You know what I mean? So you want to be able to carry in your own car. So you would put it in your car, locked away, and then whenever you got to the location that you were legally allowed to carry, you would then be able to load your firearm, put it on you, and carry about your day. However, the list of sensitive places are so broad and large that you really can't carry anywhere. So one of the other parts is private property. All private property, all of it, is de facto banned from carrying. You cannot carry on private property unless they post a sign saying that you can, or you have written permission from the owner that you can carry there. That's a big deal because, say, a place is leasing a space for whatever kind of store, okay? It's not worded that way. It's not the person who's leasing it that can give you the permission. It's the owner of the building. So there you go. And that goes for actual private property, as in, say, your best friend, your neighbor, any of them, unless you're given written permission or a sign is posted saying that they authorize carry there. So just like they talked about in the debates, where it came up that, they asked if, say, you're walking your dog in the street, carrying your firearm legally, and your dog happens to take a number 2 on a property, and you walk over to pick it up with a little doggy bag thing, you throw it away, like you're supposed to do, you're actually committing a felony by walking on that person's property to pick up the dog poop and throwing it away like you're supposed to, because you didn't get written permission. And where public and private property lines are and easements, that could be a disaster. So pretty much you can't carry anywhere. You also can't carry in libraries. You can't carry in hospitals, urgent cares. It lists daycares of all kinds. So say, example, your church has a daycare or some kind of, it's a multi-purpose building. If it happens to have a daycare in it, you can't carry at all in that building. Federal buildings of all kinds, even ones who share. So say, I don't know, just throw something out there. Say a warehouse, right? And that warehouse is split into 5 different businesses, and one of them happens to be like a Social Security Administration building, that they're renting out. But because that has a federal or state entity government in that building itself, you can't carry at all in there. You can't carry in parks, any kind, state or federal, unless you're having written permission to hunt, but that's not really carrying. Also, what else can you not do? You can't carry in places like casinos, regardless of if it's on the gaming floor or not. You can't even carry in a hotel that is attached to a casino. You cannot no longer carry while you're at a place like Applebee's, for an example. If that facility sells alcohol for consumption, whether or not you are consuming the alcohol, it doesn't matter. If they sell alcohol for consumption on that premises, you cannot carry there. So you want to go out to dinner with your family at the local Applebee's or diner that happens to sell alcohol, you can't carry there because someone else is drinking. You also, like in a youth sporting event. So if you want to go watch your son play Little League or your daughter play soccer or something like that, when they're playing in that area where they're playing, you cannot carry. So the whole purpose of defending your family when they're probably at their most vulnerable because they're playing a sport and not paying attention to what's going around them, you can't carry that. Obviously, you can't go into a bank. There's so many things within this sensitive place category. It virtually makes it, your permit is worth nothing. You can't carry anywhere. Maybe in the middle of the street. You might not even be able to walk on the sidewalk, depending on if that sidewalk is an easement to someone else's property. It's very, very iffy on what's considered what. Not only does that, make that, even if you got rid of the sensitive places argument and say, okay, you can carry everywhere, there's other things that they do. For example, there's more training that you need. I'm a fan of training. I don't have a problem with training. But if it's mandated, other than the qualification, which I think is BS anyway, but if they mandate that you have to take such and such training, and then it's so vague that they could charge you whatever they want, places, next thing you know, you're pricing out so many people because they can't afford it. I agree you should train. That should be on you. If the state says, hey, we want you to fire a few rounds and make sure that you can hit a target so you're not hurting anybody that you don't mean to hit, okay. If you want to say, show me you know how to use it, I okay, whatever. It's a little bit. I'll give you a little bit. Okay, but a bunch of extra training, like 16 hours in a classroom, I just don't believe in that. You, as a person, as a firearm owner, you should go about doing it yourself. It shouldn't be mandated. Like I said, also the fees just to get your stuff has gone up, and now they also require liability insurance that doesn't even exist yet. Which, there you go, because of the way it's worded, God knows they could end up, and it's a $300,000 insurance policy. So God knows how much that is a month. The average person might not be able to afford that, especially lower income families who are just trying to exercise their right to protect themselves, who may live in a very bad neighborhood, doesn't have the extra monthly money to pay for insurance. And then to have insurance to exercise your Second Amendment right, I think is BS. If you want some kind of insurance or legal liability insurance, stuff like that, that should be on you. That should be what you want to do. It should not be mandated by the state. So let me get into what happened about this bill that's a little bit of positive. So, this is what happened. So the moment he signed it into in the law, the two lawsuits were filed. The complaint was filed on the 22nd. Motions took place on the 23rd. So there's been some back and forth, and then there was an order issued basically saying a time frame of how the case on an emergency basis is taking place. So basically by, I don't know, the first week of January. I think it might be January 5th. Sorry, I'm a little foggy on the dates, but within the first week of January, either from certain things have to be in by the 3rd. I think there's a hearing maybe on the 5th, and then a ruling probably by the 9th. Something along those lines. Within that window. And both cases are moving very fast. They already have judges assigned to each one. And then there was a New Jersey tried. And they submitted a letter to the judges trying to consolidate both cases into one case. And the lawyer for one of the complaints did a response letter and said no, they shouldn't be joined and consolidated into one case because they're going after different parts of the law. So I don't know what the outcome of that. I just know that was the last thing that I saw, was that there was a letter to try to get the judge to consolidate, and then there was a letter to say no, they shouldn't be. And I don't think the judge made a ruling, at least yet, on that. So that leads me to this. The New York law, the CCIA, their version of New Jersey's kill carry bill, that actually was ruled, parts of it was ruled unconstitutional 4 times. Okay? 3 by one particular judge and 1 by another judge. Basically, they ruled for a temporary restraining order, and then they ruled on some parts of it being joined, and a preliminary injunction. New York filed to the Second Circuit for an emergency stay, which sadly the Second Circuit issued a 3-sentence opinion staying the lower court's ruling. The lower court's ruling, though, don't quote me on this, but I think it's 180 pages. Very detailed ruling. And they, those judges, lower court judges, used text informed by history the way they're supposed to, described in the Bruin decision. So they ruled right. Second Circuit didn't say they ruled wrong. They just stayed the order until the full case can be heard. The problem with that is it could take years for that case to be heard, meaning it could literally, this whole time, infringing on those the rights of people in New York, just like the New Jersey law is doing to us. So with the stay in place, New York can just continue to enforce their already deemed unconstitutional law. So in a surprising turn of events, something that doesn't always happen, and it's kind of rare, GOA filed for a, I don't know if it's considered a motion or an application, emergency application to the Supreme Court to vacate the stay of the circuit, of the Second Circuit, based on the fact that they are deliberately, the law deliberately does not go with the Bruin decision. Sorry, just lack of words here. But yeah, basically the CCIA of New York law basically flies in the face of the Bruin decision, because almost everything in it is a violation of the Bruin decision. So what happens in this emergency application to the Supreme Court, it bypasses the circuit and goes right to the Supreme Court. Now, the judge who is that oversees the Second Circuit is Justice Sotomayor, and I'm probably sure I didn't pronounce that correctly, but I don't care. Though she is a left-leaning judge, being that justices don't like to go in disfavor of a ruling that they just did, she's the one who's going to oversee this emergency request to vacate the Second Circuit stay. Now, there's a couple options here. One, she can rule on her own to deny it or grant it. If she denies it on her own, GOA can then refile to any judge they want to, meaning they can go directly to Thomas. And since it was his opinion that was issued in Bruin, I'm pretty sure he'll be pissed off that his opinion or his ruling in Bruin is not even a year old yet, and there's already circuit courts and states that are completely not following the decision. The Supreme Court is the supreme law of the land. What they say is, until it's overturned, whatever, by another Supreme Court. But that's standing law. You need to follow it. So, she would have to deny it on her own for GOA to appeal that to another justice. She can also grant it on her own, or she can put it up for a full court vote. And then we'll see. Now, if the full court votes on it and denies it, then it's done. So what happened was she just released her an opinion on it, basically a ruling of some sort. She basically said she did not deny it and she didn't grant it, but she gave New York, I believe, until January 3rd or 5th to issue a response, basically telling New York, you need to show me why you did this, before she's going to either grant or deny that emergency application. So it's going to be very hard for New York to justify that law based on Bruin. Though she might not like the Bruin decision and she technically voted against it, but precedent, it's what's law. She's going to basically have to apply that. So whatever New York sends her, they're going to have a hard time, making a point, because Bruin is what it is, and Justice Thomas is her colleague. So we'll see what happens. But if she rules that to vacate the stay, because New York has no standing on this, she could just vacate it and let it go with no opinion. She doesn't have to issue an opinion. Or she could issue an opinion, or it could go to the full court and get their input before writing an opinion. And the deal is, if she writes an opinion, okay, basically she could chastise all the lower courts and circuit courts. She can basically say, or the court itself can say, you guys are doing it wrong. You need to apply Bruin as written. And and then boom, that's case law now, right? So moving forward on New Jersey's side, if that happens, and the time frame of this stuff is all going to be within the same week, she had to have an opinion or deny or grant that that emergency application by January 2nd, I believe. So she did answer it, but this is going to be a fast moving thing. So at the same time, New Jersey is hearing their temporary restraining order or preliminary injunction on A 4769, they could also be getting the ruling for the Second Circuit stay from the Supreme Court. So it is very possible that even though it's in a different circuit, if the Supreme Court vacates the stay, then New Jersey, us, not New Jersey himself, but us, who are fighting this kill carry bill, can cite the Supreme Court saying, look, the Supreme Court agreed with the lower court in New York that these laws, which New Jersey's is extremely similar to what New York passed, is unconstitutional, at least on its face. Therefore, it would give us the ability to get our temporary restraining order or preliminary injunction, at least until the case is fully heard, meaning the law that's in place, or at least parts of it, would not be enforceable. Therefore, we could go back to people who have carry permits can go back and do what we were doing prior to December 22nd. I know this is a long-winded video today, but I wanted to get you guys caught up on what's been going on in New Jersey and New York, because they kind of are going to play hand in hand. This first week of January, second week of January is going to be flooded, possibly with good news or bad news, but it is what it is, and we got to roll with the punches, and we have to fight back on this because, for me personally, if you guys been following my videos, it took 5 years almost to the day from my first application to actually getting my carry permit. So that's a 5-year fight, on and off, but a 5-year fight nonetheless. And and just for it to, what's that? August, September, October, November. So I had the freedom to carry for roughly 4 months, and then it was taken away from me again just by a signature. Even though I technically have my permit just like the other 100,000 people who've got their New Jersey permit, that's probably a high number, but in general, the ones who went and got their carry permit after Bruin, their permit is basically useless right now. So we basically had freedom for about 4 months. So we definitely have to fight back, and this is such a new thing here in New Jersey, because most of the time in years past, a lot of the organizations, at least on the New Jersey side, was looked at as a redheaded stepchild, and you had different groups here fighting with opinions on when's a good time to fight a case, or what to fight, or how to fight. Never ever were they ever on the same page as they are right now. All the 2A cases, though they might attack different, all the Second Amendment groups, though they might want to attack different parts of the law, we are all on the same page in the fact that we all agree, and they're all working together for the first time, at least since I can remember, in one common goal, and that is to kill the kill carry bill. And and strike it down as unconstitutional and go from there. I will say there's parts of the bill that are not fully bad. For one, and probably the most important thing that I agree with, is they removed judges from the permit application process. Moving forward, the judge is no longer involved. So your local chief, or if you don't have a police department, it would be the state police. They would become the issuing authority. And I got something else coming out when I get some more information about that, because people who already had their carry permits, if they wanted to qualify with a different firearm, we were supposed to submit our applications to our local PD, and they would send it to our county judge for them to update our court order stating that we can carry that firearm. But with this new law in place, and courts are no longer involved, and people who have their permits already have their permits signed off by a judge. So they're not signed by the chief of police. So would they have to be reissued and signed by the chief of police? Or do we get grandfathered in and still have to go through the process on submitting to the county judge for them to update our orders? Or is the J Factor case that was just ruled on, that basically says that we can get carry permits without restrictions, does that come into play? There's a lot going on there, and when I get more information, I will post a video about it. But until then, peace. What's going on? Before I forget, guys, I just want to let you know that I left links in the description so you can go and research and read for yourself some of the stuff that I talked about in my video today. Also, if you're not doing it already, I don't know where you've been, but you need to check out Gun for Hire Radio and listen to his podcast. Anthony's a great dude and supplies a lot of information. You need to go check him out if you're not doing it already. But until next time, peace. Pistol on my waist and my rifle's in the safe, with a shotgun on the wall with lots of shells up in the case. I got that pistol on my waist and my rifle's in the safe, with a shotgun on the wall with lots